Okay. Very good evening, students. Very good evening, Sapna. Let everyone join, and within 2 minutes, we will start the session. Okay. Okay, students. So I am starting this session now. Very good evening, Amit, and everyone, those of you who have just joined. So I welcome each one of you to my YouTube session on the Indian Evidence Act 1872. Let's start with my brief introduction. First, my name is Sandeep Khatri. I have done my law from University of Mumbai and my LLM from Jindal Global Law School. By profession, I'm a teacher. I'm teaching law. These are my areas of specialization. As you can see on the screen, the constitutional law, criminal law, commercial law, family law, and law of torts. This is the link of my profile on Unacademy, so please do follow that to get all the updates about my special classes and plus courses. This is the link of my Telegram channel where you can connect with me. And at last, I have mentioned my code KHATRILIVE, which you can use to get free access of all the special classes available on Unacademy. And in addition to that, to get 10% discount for all the plus courses. So this was about me. I request everyone, please be attentive, and this is going to be an interactive session. So the moment you feel you're not clear with any of the questions, feel free to write your questions in the comments. So before starting the MCQ, very good morning, Mausami. Sapna, all good. I am completely recovered now. Okay. So if you all are ready, quickly give me a thumbs up. I will start the session, students, with the questions. Yes. Today we have total 50 questions. So if you all are ready, quickly give me a thumbs up. Okay, perfect. Perfect. So here comes the first question, students. Just before starting the test, one humble request: make sure you first write the question number and then whatever your answer is, A, B, C, D. Okay. Now here comes the first question of this class. The Indian Evidence Act is drafted by, I think, the most common and easy question which one should know about Indian Evidence Act, that this act has been drafted by. First one to answer, Sapna. Very good evening, Shalini. Okay, everyone is answering D, that is Sir James Stephen. This is the correct answer, students. One more thing, one additional fact I want to state here is that Sir James Stephen has also drafted the Indian Contract Act 1872 as well. Okay, so next one. The law of evidence is. The law of evidence is. Yes, Amit, correct. Which one is the correct option? First one to answer, Shalini, B. Then Sapna, B. Meenal is also answering B. And B is the correct answer, students. Lex fori. The term court defined under section 3 does not include. First one to answer Shalini, then Ekta, then Shivam. Okay, Preeti has also answered. Okay, C is the correct answer, students. That is arbitrator. Mosmi, please do a refresh. I don't think there is any issue from my end. Yes, facts can be physical, psychological, both, none of the above. First one to answer Ekta, then Shalini, and after that Preeti. Yes, student, C is the correct answer. Followed by everyone. Yes, everyone is answering C, and this is the correct answer. Which of the following statements is true? Waiting for your answer in the comments. Okay. Indian Evidence Act is exhaustive or not? Student, the answer is B. Indian Evidence Act is not exhaustive. Okay, so B is the correct answer. How many sections and chapters in Evidence Act? First one to answer Sapna, followed by Shalini, Amit, and everyone. D is the correct answer, students. 167 sections and 11 chapters. There are certain objects arranged in certain order at certain place. This is called what? Fact, opinion, document, motive. First one to answer Sapna, followed by Shalini and Mosmi. Everyone is answering A, and that is the correct answer. It's a fact. The relevant fact, and these are your options. The relevant fact. First one to answer Sapna, then Amit, followed by Mosmi, B, top three students to answer B. And yes, students, B is the correct answer. The relevant fact must be legally relevant. Proof is the result of. Correct, Mosmi, 5 to 55. Preeti, both the answers are correct. 5 to 55 as well and 6 to 55 as well. 5 to 55 on the basis of, because of the heading of the chapter starts with relevant facts. First one to answer Sapna, followed by Mosumi and Shalini and everyone else. Everyone is answering C and the answer is correct. Proof is the result of evidence. The affidavit given to the court is first one to answer Sapna A, Mosmi A, and Shalini is also answering A, followed by everyone. Yes, students, the answer is correct. The affidavit given to the court is not an evidence. Evidence law is not applicable on affidavit. Next. Evidence means and includes. First one to answer Sapna, followed by Mosmi and Shalini. Yes, everyone is answering C, and that is the correct answer. Which of the following is not mentioned in document under section 3? The term document has been defined under section number 3, but which one of those terms are not part of the definition, that is of document? First one to answer Sapna, then Mosmi and Shalini. And yes, students, C is the correct answer. Symbol is not mentioned in the document. Circumstantial evidence is direct evidence, indirect evidence, material evidence, neither A nor B. Sapna, first one to answer. Followed by Shalini and Kriti. And yes, students, B is the correct answer. Circumstantial evidence is indirect evidence. Evidence sought through unfair means is first one to answer Sapna, followed by Kriti and Amit Pandey. Top 3 to answer. Shalini, circumstantial evidence has no specific section, but still this is one kind of evidence. And B is the correct answer, admissible if relevant. Res geste means first one to answer Sapna, followed by Kriti and Shalini, top three to answer. And the answer is A. A is the correct answer, that is things done. Under section 8, what is going to be relevant? First one to answer Shalini, followed by Divyam and Sapna, top three to answer. D is the correct answer. Admission defined under section. Which of this section define the term admission? First one to answer Sapna, followed by Kriti and Amit. Yes, students, section number 17 is the correct answer. The term confession is defined under section. Kriti, first one to answer D. Shalini, D. Sapna, D. Yes, students, D is the correct answer. The term confession has not been defined in the Indian Evidence Act. Confession before the police. First one to answer correct, that is Amit, followed by Kriti and Sapna. C is the correct answer, students. That is will not be proved. Dying declaration may be made to. Yes, completely correct, Amit and Shalini. That is section number 25 we are talking about. First one to answer Sapna, followed by Amit and Shalini, D. And everyone is answering D. And yes, this is the correct answer, students. D, all of the above. The principle of res judicata is provided in which of the following sections? First one to answer, Sapna, 21A, Shalini and Preeti, and followed by everyone. Everyone is answering A, and this is the correct answer, students. Section number 40. The opinion of expert is not relevant. On which point the opinion of expert is not relevant? First one to answer, Sapna, followed by Aditya and Ayushi. A is the correct answer, students, on the point of Indian law. Under which section DNA test can be admitted in evidence? First one to answer, Amit, followed by Sapna and Mosmi. B. Aditya has answered A. Okay. Aditya, the correct answer is B here. That is section number 45. When we talk about DNA, this will fall under section number 45. The relationship in section 50 of Evidence Act means. What kind of relationship they are talking about? Blood only, blood or marriage, blood, marriage or adoption, none of the above. First one to answer, Aditya. Okay, no. First one to answer, Sapna, followed by Aditya and Preeti. And the correct answer is C, students. C is the correct answer. Blood, marriage or adoption. Under which of the following section bad character of the accused is not relevant? Where bad character of the accused is not relevant. First one to answer, Sapna, followed by Shalini and Aditya and everyone. And everyone is answering A, that is section number 54, which is completely correct. Which of the following facts need not to be proved? Oral evidence, documentary evidence, facts taken judicial notice by court, or relevant facts? First one to answer, Aditya, Shalini, followed by Sapna and everyone else. Yes, C is the correct answer. Oral evidence under section 80 must be. First one to answer, Sapna, Aditya and Shalini. And yes, students, D is the correct answer. That must be direct. Which section recognizes the principle that hearsay evidence is no evidence? Which section is this one? Very good evening, Anil Dikshit. First one to answer Sapna, then Preeti, and then Chandrakant. And yes, students, B is the correct answer. That is section number 60. Chapter number 5 of Indian Evidence Act deals with which of the following concept? First one to answer, that is Ekta, followed by Preeti and Amit. Top 3 to answer correctly. That is B, which is documentary evidence. Good evening, Pooja Singh. Photocopies made from original are primary evidence, secondary evidence, hearsay evidence, none of the above. Photocopies made from original. Zenith Khan, I don't think so. RJ's admit card has been issued till now. First one to answer Aditya, then Pratibha, and then Damini. And the correct answer is, students, secondary evidence. Which of the following is best evidence? First one to answer Aditya, followed by Ayushi and Sapna, and everyone is answering C. This is the correct answer, students. Direct evidence is considered as the best evidence. How many years old electronic record will be deemed to be proved if it is produced from any custody which the court in the particular case considers proper? First one to answer Aditya, followed by Sapna and Mosmi. And everyone, A is the correct answer. 5 years. Section 75 deals with First one to answer correctly, 33, that is Sapna, Shalini, and Chandrakant Pandey. A is the correct answer, that is private documents. Which of the following is not a public document out of these? First one to answer, Sapna, followed by Pratibha and Amit. D is the correct answer, students. D, will is not a public document. Which section is not on shifting of burden of proof? First one to answer, Sapna, followed by Pratibha and Mosami, top three to answer. Student, this is your section number 101. The section 101 is never shifting from one person to another person. So A is the correct answer. The principle of proving beyond reasonable doubt applies to civil proceedings, criminal, evidence law, both A and B. This is both A and B, students. H is missing here, so both A and B. First one to answer, Sapna, followed by Aditya and Pratibha. Top three to answer correctly. That is criminal proceedings. Yes, students, this is the correct answer. B. A period is presumed to be alive if it is shown that he was alive within. First one to answer correctly, Sapna, Aditya and Amit. C is the correct answer, students. That is 30 years. Burden of proving fact, especially within knowledge. Which is going to be the answer? First one to answer correctly is Sapna, Chandrakant and Mosmi. D is the correct answer. D is the correct answer. Section 106. If a child is born within dash days after the dissolution of a valid marriage, it is a conclusive proof of the legitimacy of the child. How many days? That has been mentioned in the given provision. First one to answer, Aditya, followed by Shalini and Sapna. C. Yes, this is related to your section 112, and C, 280 days is the correct answer. Section 114 provides for first one to answer, Mosmi, followed by Sapna and Pratibha. A is the correct answer, students. Who is a competent witness? Child, rape victim, lunatic person, all of the above. First one to answer, Aditya, followed by Pratibha and Sapna. D is the correct answer. These all are the competent witnesses. Under section 122, privilege is available to first one to answer correctly, that is Amit, Mosmi and Sumit. That is wife and husband. B is the correct answer. Students, this is not sales, this is salus populi. Is supreme lex based on which of the maxims? This maxim is based on which of the following sections? This is SALUS. This is LUS. Spelling mistake. First one to answer correctly, that is Shalini, followed by Mosmi and Sapna. A is the correct answer, that is section number 123. Cross-examination of one's own witness is permissible or not permissible? First one to answer, Aditya, followed by Ekta and Sumit. C is the correct answer, permissible with the consent of the court. Admissibility of evidence is to be decided by. Who is going to decide whether the evidence will be admissible or not? Who is the authority? Aditya is the first one to answer. B, followed by Sapna and Shalini, and everyone else is answering B only. This is the correct answer, students. Judge. Leading questions defined under section. Mostly this is not section 165. This is section 137. Sorry, 136. Shalini and who else has answered? Mosmi. Please note this down. This is not section 165 about the admissibility. That is the section number 136. Okay. And as far as question number 46 is concerned, first one to answer is Aditya, then Pratibha, and then Sapna. C is the correct answer, section 141. Leading question can be asked. Okay. B is the correct answer, students. First one to answer Sapna, followed by Ekta and Chandrakant. B, cross examination is the correct answer. Testimony of hostile witness to be. Testimony of hostile witness to be rejected, partially accepted, considered with caution, and be corroborated. First one to answer correctly, Aditya, followed by Mosmi and Preeti. D is the correct answer, that testimony will be considered with caution and be corroborated. Next. Indecent and scandalous questions may be forbidden by the court under section. First one to answer Aditya, followed by Shalini and Chandrakant. A is the correct answer, 151. Court questions under section 165 can be put to. First one to answer Aditya, then Sapna and Pratibha, and C is the correct answer, students, both A and B. So these are the 50 questions from today's class on Indian Evidence Act. Now any question you are not clear with, on any question you want my explanation on, any answer you are not satisfied with, this is your time to ask questions related to any of the questions. Yes, please. One by one. And if it's all clear, quickly give me a thumbs up. I'll wrap up the session. Yes, please. Questions. Any question you are not clear with. On any question you want explanation. And if it's all clear, quickly give me a thumbs up. Okay, Mosmi is asking about question number 14. Okay. Evidence sought through unfair means. Uh, Answer to your question, Mosmi, there is no specific section on this one, and that is why the answer is admissible if relevant. Okay. You can also read section 29 for this one, where one person, if the one person is deceiving to get the evidence, to get the confession, even that is completely relevant. Okay. So there is no section which prohibited the police officer that if the evidence is sought through unfair means, that would not be treated as relevant. Okay. So that would be admissible if relevant. Anything else, students? I hope Mosmi it is clear now. Okay, perfect. So I'm taking other questions. Pratibha, you are asking about question number 48. Just give me a second. Yes, testimony of hostile witness to be. See, I hope everyone knows the basic meaning of the hostile witness, which means suppose if a prosecution calls a witness to prove that this person accused has committed this offense, and now this person is passing such statements which is completely in the favor of the accused only. So that person is called basically the hostile witness. In that case, students, his testimony is going to be considered with caution. Okay, because this is something which may mislead the court. So the court will take the caution and it will be considered with caution and be corroborated. As much as his testimony can be corroborated with other evidences, the court will admit that. And if there is no corroboration with other evidences, the court is not going to take the testimony of the hostile witness into consideration. Yes, anything you are not clear with from question number 48? Aditya, your statement is completely correct, but that is in the exceptional case. Okay. And as far my question is concerned in this test series, that was talking about the general rule. Okay. In the general rule, without any exceptions, leading questions should be asked in cross examination only. But with the permission of the court, you can ask leading questions in the examination in chief as well. Okay. Okay, Anil is asking about question number 47. Okay, Anil, I have just explained this. Leading question can be asked. So, as a general rule, they are not talking about the exceptions, they are talking about the general rule. So, the answer is cross examination. Okay. Amit, answer to your question, examination in chief is something, for example, if the prosecution is calling a witness, okay, if there is a witness which is prosecution witness, so the on the when the prosecution witness will come to the court and give evidence, the first stage is examination in chief. You know, all the communication between the public prosecutor and the prosecution witness, that all will be considered as your examination in chief. And once examination in chief is done, then the cross examination will be done by the defense. Okay. So, and similarly, if a defense is calling a witness, so and when he is giving evidence in favor of the accused, that is your examination in chief. Ekta, unfair means there is no particular section on unfair means, but somehow to very short extent, okay, to very some extent, you can say that section 29 use one word deception. Okay, you cannot say that section 29 is the exact answer of that question. No, that is not the case. Okay, so just because section 29, so see, the first main answer of that question would be that when it comes to taking evidence through unfair means, there is no particular section in the whole Indian Evidence Act that makes that evidence irrelevant. Okay, first thing. Second thing, you may mention section 29 there as well, ki if someone is taking someone's confession through deception, okay, so all the evidence that has been taken through deception, that would be relevant under section 27. Okay, I hope I have answered everyone. If I have missed anyone's question, you may please copy and paste it again. Are we done, students? Or you want anything else? Okay. Then on that note, students, now I'm wrapping up this session. So this is the link of my profile on Unacademy. Make sure you follow that. This is my link of my Telegram channel where you can connect with me and ask questions related to judicial preparation. This is my code KHATRILIVE, which you can use to get free access of all the special classes available on Unacademy app, and also to get 10% discount for all the plus courses. This is the schedule of my classes. Tomorrow I'm going to take a full-fledged test of 125 questions in my special class from 2 to 3 p.m. So make sure you don't miss that. This is completely free of cost. And this is my YouTube sessions are going on. And these are my plus classes on Hindu law and Indian Evidence Act 1872. So let's crack PCS J with Unacademy, compete with thousands of aspirants and stand out from the crowd. You will get all the subjects here, students, all the major, minor, local laws, family law, GK, current affairs, everything is available for you. These are some special class features, interactive live classes, poll for learners. You can raise your hand and you can speak with the educator. You will get the notification, so you will never miss a class. You will get the lecture notes and you can access it anytime, anywhere. These are some additional features. This is the free test series going on for RGS and HGS exam 2021. So you should take benefit out of this as well. These are the rapid revision series going on for RGS and HGS. This is the pricing plan and the plus subscription, students. More the months, less the price, and you can always use the code KHATRILIVE to get 10% off. And once you are a subscriber, you can attend all these classes. This is the YouTube and the Telegram channel of Unacademy. And at last, thank you very much. Like, share, and subscribe. Yes, Amit. Yes, completely correct. Pratibha, the time is up as of now. You can do two things. Either you can ask me the same question on my Telegram channel and I'll reply there, or you can ask me tomorrow at the same time. Okay. Yes, Ranjit, you can ask your questions on my Telegram channel. Okay. Okay, students. So on that note, take care, goodbye, and it's time to say peace.